I want you to imagine a scenario that sounds like the plot of a psychological thriller, but it's actually just a bureaucratic nightmare. Imagine you're living your life, you've gone through a divorce, it was amicable, you signed the papers, the government stamped them. In the country where you live, you are single, you're free. You could meet someone new, get married again, completely move on. But then you take a flight back to your home country, you land, you go through customs, and the moment the wheels touch the tarmac, your legal status changes.
It's like stepping into a time machine you didn't ask for.
Right. Suddenly, legally, you are still married. You are bound to an ex-spouse you haven't been with for years. You are single in one place but married in another. It's a split reality.
It is a paradox. And unfortunately for thousands of people navigating international relationships, this isn't a hypothetical. It is a very real legal limbo. Legal scholars actually have a term for this specific state of affairs. They call it a limping marriage.
A limping marriage. Wow, that is such a visceral image. It implies something broken, something dragging along that shouldn't be there. And today we are doing a deep dive into a specific case that perfectly illustrates this nightmare. We're looking at the case of Genevieve Rosal Ariza v. Tatsushi Toyo, or GR Num 213198.
This case is a fantastic lens to view this problem through because, on the surface, it looked like a simple breakup story. But when you peel back the layers, it is actually a complex clash between personal status, who you actually are in the real world, and the strict, sometimes incredibly rigid, evidentiary rules of the Philippine judicial system.
What drove me crazy reading through the sources for this is that the court actually believed her. They knew she was divorced. This wasn't a case of did they or didn't they. Everyone knew it was over. But the court still said no.
And that is the core tension we need to explore today. The massive gap between knowing a fact is true in a common sense way and, proving a fact in a court of law. Because as Genevieve found out, you can have the truth on your side, but if you don't have the right stamp on the right piece of paper, the truth might as well be fiction.
So let's unpack this. We need to start with the people involved to understand the stakes. We have Genevieve, a Filipino citizen, and Tatsushi, a Japanese citizen.
They got married back in April 1991 in Quezon City. They started their life together, had a child named Kiichi. But, as happens in life, the marriage didn't last. They were together for 19 years, a significant amount of time, but eventually they decided to part ways.
Now, they were presumably living in Japan or at least handling their affairs under Japanese jurisdiction at this point. And from what I see in the sources, Japan handles divorce very differently than the Philippines, it seems. Shockingly easy.
Compared to the Philippine system, it's night and day. In Japan, they have a mechanism called divorce by agreement. It's administrative. You don't necessarily need a long, drawn-out trial where you throw mud at each other, provided both parties agree to the split.
So it's basically, we agree this is over, sign here, and you're done.
Effectively. In February 2011, they filed a notification of divorce. The mayor of Konohana-ku in Osaka City received it, and crucially, it was recorded in Tatsushi's family register. In Japan, that's the gold standard. It is a done deal.
Okay, so in Japan, the book is closed. Clean break. But Genevieve is Filipino. She wants this divorce recognized in the Philippines so she can be legally single at home, too. She doesn't want that limping marriage. So in May 2012, she goes to the Regional Trial Court, or RTC, in the Philippines.
She files a petition for the judicial recognition of foreign divorce. Basically, she is asking the Philippine court to look at the Japanese documents and say, okay, we acknowledge the reality of what happened in Osaka, so we recognize that you are capable of remarrying here.
And looking at the file, she came prepared. This wasn't someone walking in empty-handed. She brought the divorce certificate. She brought the Japanese family register showing the divorce. She brought the certificate of acceptance. And she brought an English translation of the Civil Code of Japan. She literally brought the law book to court to show them, look, this is the law that allowed me to divorce.
It sounds like a slam dunk case. The regional trial court looked at all of this. They held a hearing. And keep in mind, no one even showed up to oppose her petition. Tatsushi didn't fly in to contest it. The Solicitor General didn't fight it. It seemed like the easiest decision a judge could make.
And yet, on Valentine's Day of 2014, which is just a cruel twist of irony, the court rendered its judgment. They denied her petition.
It must have been devastating.
I don't get it. The source says the court found the petition sufficient in form and substance initially, and they agreed the divorce documents were accepted by the local government in Japan. So they agreed the divorce happened. Why deny her?
The court ruled that while she proved the fact of the divorce, meaning the event itself, she failed to prove Japanese law.
Wait, hold on. She brought the English translation of the Civil Code of Japan into the courtroom. She placed it on the desk. How can the judge say she failed to prove the law when she was physically holding the law in her hands?
This gets us into a really important legal concept called judicial notice. If you walk into a Philippine court and cite the family code of the Philippines, the judge knows it. You don't have to prove that the law exists or what it says. The judge takes judicial notice of it. It's assumed knowledge because it's their own country's law.
Sure, that makes sense. You don't have to explain the rules of basketball to an NBA referee.
Exactly. But a Philippine judge is not expected to know Japanese law or American law or French law. To a Philippine court, foreign law isn't actually law. It is considered a fact.
A fact, like the sky is blue or the car was red.
Yes. And like any other fact in a trial, say, proving a car accident happened at 2 p.m., it must be pleaded and proven with evidence. You can't just say, this is the Japanese law. You have to prove, using specific rules of evidence, that this text is indeed the current valid law of Japan.
But isn't that just pedantic? I mean, we live in the information age. Why couldn't the judge just Google it? Why is the burden so heavy on Genevieve?
Well, it's about sovereignty and reliability. A Philippine judge has no authority to interpret the laws of another sovereign nation on a hunch. They need absolute certainty. And this is where Genevieve's case hit a massive wall. The problem wasn't the content of the law she submitted, it was the source of the document.
Let's look at that document. It says here she provided a copy of the Civil Code of Japan, translated by a company called Ibn Shah, Inc.
The EHS Law Bulletin series is a very well-known private company in Japan. They translate laws into English for businesses and expats. Genevieve argued that this was an official publication because the book explicitly stated it was printed under the authorization of the Ministry of Justice regarding copyright.
That sounds official to me. If the Ministry of Justice says, we authorize you to print this, isn't that the government giving it a thumbs up?
You would think so, and that was Genevieve's argument. But the Supreme Court said absolutely not. And here is where we get into the nitty-gritty of the rules of court, specifically Rule 132. To prove a foreign law, you generally have two gold standard options. Option 1. You produce an official publication published by the foreign government itself.
Like an official government gazette.
The Kampu in Japan, yes.
Yeah.
Option 2. You bring a copy that is attested by the legal custodian of that record, the government archivist. And that copy must have a certificate and seal from a Philippine consular officer in that country.
So we're talking about the ribbon, the red wax seal, the whole diplomatic package.
We are talking about the chain of custody. The court pointed out that Ibn Shah is a private corporation. It's a business. It is not the Japanese government. Just because the government gave them permission to use the text, a copyright authorization, doesn't mean the government verifies the accuracy of the translation.
I see. So it's like the difference between citing the official government website versus citing a textbook written by a professor. The textbook might be right, but it's not the law.
Or perhaps even more starkly, it's like trying to prove a fact using a Wikipedia printout.
Yeah.
The Wikipedia entry might be correct, but the court doesn't view it as an authoritative, self-authenticating source. Without those diplomatic chains of authentication, the consular seal, the document, is just a piece of paper from a private company.
That is incredibly strict. I mean, imagine being Genevieve. You know you're divorced, the judge knows you're divorced, but because your translation of the law came from a respected private publisher instead of the official gazette, you're still married. It feels like form over substance.
It is strict, but look at it from the court's perspective.
Mm-hmm.
If they accept a private company's book today, what do they accept tomorrow? A blog post, a translation found on a forum. They need a line in the sand to protect the integrity of the judicial record.
Okay, fair point. But Genevieve didn't give up there. She had a backup argument, right? I saw something in the notes about a learned treatise.
This was her plan B. She argued, okay, if you won't accept it as an official public document, accept it as a learned treatise. In law, a learned treatise is like a respected textbook or a journal article written by an expert in the field.
Like if you were in a medical malpractice trial, you might bring in a medical journal to prove a heart surgery procedure was standard.
That's a great example. But here's the catch, and it's a big one. Written evidence, like a book or a journal, is technically considered hearsay.
Wait, hearsay? I thought hearsay was gossip. He said, she said. How can a printed book be hearsay? A book doesn't lie. It doesn't change its story.
In the legal definition, hearsay is simply an out-of-court statement offered to prove the truth of the matter asserted. The key issue is cross-examination.
You can't cross-examine a book.
You can't. The author isn't sitting in the witness stand. You can't ask the author, are you sure this translation is accurate, or has this law been amended since you printed this in 2011? Because the author isn't there to answer, the evidence is considered unreliable.
So the book is just the author talking without being under oath and without being there to defend their work.
That's the logic. Now, there is an exception. The rules of court say a treatise can be admitted if the court takes judicial notice that the writer is an expert, OR, and this is the crucial part Genevieve missed. If a witness testifies that the writer is a recognized expert.
Let me guess. She didn't bring an expert witness to say, hey, this translation company is the best in the business.
She did not. She just pointed to the inside cover of the book, which listed the credentials of the translators and advisors. She basically said, look, the book says these guys are smart.
Yeah, I can see why a court wouldn't accept because the book says so, as proof of expertise. That's circular logic.
The regional trial court refused to take judicial notice of the writer's expertise just based on the book cover.
Yeah.
So the hearsay rule applied, and the book was thrown out as evidence.
It feels like Genevieve was caught in a trap of technicalities. She had the facts, but she missed the procedural steps. Which brings us to the bigger picture here. Why do we even make Filipinos go through this? I'm looking at Article 26 of the Family Code. The whole point of this law is to help people, right?
Article 26, specifically the second paragraph, was actually an amendment added specifically to fix the absurd situation we talked about earlier.
The limping marriage.
Right. Before this amendment, if a Filipino was married to a foreigner and the foreigner got a valid divorce abroad, the foreigner was free to remarry. But the Filipino was still stuck, legally married to a person who was no longer married to them. Article 26 says if the alien spouse gets a valid divorce abroad that allows them to remarry, the Filipino spouse shall also have the capacity to remarry.
So the law is explicitly on her side. The law exists literally to help people like Genevieve avoid this limbo.
The intent is there. But the Supreme Court emphasized that to claim this right, you have to prove two things. One, the divorce decree itself. And two, the national law of the alien spouse. You have to prove that under Japanese law, this divorce actually allows Tatsushi to remarry.
Because if he can't remarry, she can't remarry.
It's based on reciprocity. And since she failed to technically prove the Japanese law regarding remarriage, because of the translation issue, she couldn't trigger the benefit of Article 26.
This is frustrating me just talking about it. It feels like the procedure is defeating the purpose of the law. The law says, we want you to be free, but the procedure says, only if you get the ribbon from the consul. It feels like a gotcha moment.
And that frustration is valid. It highlights the friction between substantial justice, doing what is right, and procedural law, doing it the right way.
Yeah.
But here is where the story takes a turn toward the hopeful. The Supreme Court recognized this dilemma.
So what was the final ruling? Did they just slam the door in her face and tell her to start over?
They did not. The Supreme Court actually agreed with the lower court that the documents were technically insufficient. They didn't bend the rules on evidence. They said the RTC was correct to reject the unauthenticated translation.
That sounds like she lost.
But they didn't dismiss the case entirely. Instead, they remanded or referred the case to the Court of Appeals.
Why the Court of Appeals? Why not just decide it there? Why keep kicking the can down the road?
Think of it like a sports game. The Supreme Court is like the head referee who reads the rule book. They decide what the rules are. They don't usually watch the instant replay to see where the ball landed. That's a question of fact.
Okay, so the Supreme Court deals with the theory of the game, not the specific play.
Generally, yes. Whether Japanese law exists and what it says is a question of fact. The Supreme Court isn't a trier of fact. They don't hold hearings to look at new evidence or flip through new books. But the Court of Appeals does possess the power to receive evidence.
I see. So they are passing the baton to a court that can actually look at the new authenticated documents.
Yes, exactly. The Supreme Court cited a precedent, Medina v. Koike, and basically said, procedural rules are intended to ensure the proper administration of justice, not to override substantial justice. They acknowledged that dismissing the case would just force Genevieve to start all over again, refiling, paying fees, waiting years. That would prolong her marital limbo.
So they chose substantial justice over rigid technicality.
They found a middle ground. They upheld the rule, saying, yes, you strictly need to authenticate, but they offered a remedy. We will let you fix it in the lower court rather than throwing you out.
That is a huge relief, honestly, but we also have to acknowledge the cost. Remanding isn't free. That's more lawyers' fees, more time, more stress for Genevieve. She's been fighting this since 2012.
It is a significant burden. It's not an instant win, but it is a path forward that saves her from going back to square one.
It really highlights how careful you have to be when you're dealing with cross-border legal issues.
Yeah.
You can't just assume that because something makes sense to you, it counts in court.
That is the ultimate takeaway for our listeners. In international family law, possessing the truth is completely different from possessing the legal proof. A private translation might be 100% accurate, it might be the best translation in the world, but if it doesn't have the official status or the consular seal to the court, it's just hearsay.
It's a warning label for anyone listening who might be in a similar situation. Official has a very specific meaning. It doesn't just mean looks professional, it means verified by the state.
Courts are conservative institutions by design. They rely on sovereignty and diplomatic protocols. They don't rely on private companies, no matter how reputable, to tell them what the law of another nation is.
So if you are bringing a foreign law into a Philippine court, get it authenticated. Go to the consulate. Get the seal. Don't rely on the book you bought online, even if it has a nice cover.
Do not cut corners on authentication. It is the bridge between two legal systems. Without it, you are stranded.
You know, this leaves me thinking about the modern world we live in. We're so used to information being instant. I can pull up the Japanese Civil Code on my phone right now. I can probably find 5 different translations in seconds. I can video call someone in Japan.
The world has shrunk. Information is fluid.
And yet, the court system is still operating on a system of wax seals, ribbons, and physical diplomatic pouches that feels like it's from the 19th century. It raises a provocative question for you listening. In an era where information is instantly accessible globally, does strict adherence to these diplomatic authentications protect the integrity of the court? Or does it unnecessarily obstruct the lives of ordinary people seeking to move on? Is it time for the law to catch up with the information age? Or is that physical seal the only thing keeping the legal system from descending into chaos?
That is the tension between stability and efficiency. And in Genevieve's case, she got caught right in the gears of that machine.
A fascinating, if frustrating, look at the machinery of justice. That's all for this deep dive into the case of Areza v. Toyo. Thanks for listening.